Good afternoon, everyone, and welcome to the webinar, Higher Education, Dispelling Myths to More Effectively Prosecute Campus Rape. My name is Charlie Whitman. I'm an Associate Attorney Advisor at AEquitas, the prosecutor's resource on violence against women, and I will be moderating today's webinar. This presentation will provide a comprehensive overview of sex offenders with an emphasis on non-stranger rapists, such as motivations and characteristics, myths and misconceptions, serial and crossover offending, and will focus on strategies for overcoming the unique challenges these offenders present on campuses. Before we begin the substantive portion of our program, I will provide a brief overview of our iLink webinar service. For the best use of iLink, I strongly recommend using our conference call line at 530-881-1212, passcode 202-731-738, and that you call in from a landline. That number is also located in the upper left-hand portion of your screen. If you are using a mobile phone, please do not use the speaker option, but listen with an earpiece if necessary. All call-in participants have been muted for the duration of today's webinar. You can also listen to this presentation using your Internet audio. To connect to the Internet audio, please click the Connect button on the start screen of today's iLink session. If you use the audio option, please do not also call into the webinar, but only do so if you experience technical difficulties with your Internet audio. If you experience technical issues, you can contact iLink directly at 1-800-799-4510. You can also use the iLink hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen above the presenter's photo and to the right of the conference call number. We encourage you to pose comments or questions via private chat through today's presentation to me, Charlie Whitman, and I will share questions anonymously with our presenter so they can be addressed during today's webinar. Public chat has been disabled. Today's webinar is hosted by AEquitas, the prosecutor's resource on violence against women, through funding from the U.S. Department of Justice Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and the presenter's biography, will be emailed to you following today's presentation. In addition, today's webinar is being recorded for later viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conducts legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter is Christopher Mallios, Attorney Advisor at AEquitas. Prior to joining AEquitas, Mr. Mallios served as Chief of the Philadelphia District Attorney's Office, Family Violence and Sexual Assault Unit. He also served as an advisor for the Philadelphia Police Department Special Victims Unit and Internal Affairs Division, and co-chaired the Law Enforcement Subcommittee of the Philadelphia Domestic Violence Task Force. Mr. Mallios is currently an adjunct professor at the University of Pennsylvania School of Social Policy and Practice and an affiliate of the Ortner Center on Family Violence. I'd now like to turn the floor over to Chris for the substantive portion of today's presentation.
Thank you, Charlie, and thank you to all the participants who are attending today. I am Chris Mallios, and I want to thank you for joining us and for finding that we were more important than the World Cup soccer game today. Let's talk a little bit about this topic generally, about the topic of sexual assault on college campuses, by talking a little bit about the scope of the problem. We know from the research that sexual violence on college campuses is common. And one of the misperceptions about campus rape is that it doesn't happen that often. And it's just not true. It's extremely pervasive. And the research shows that 1 out of 5 women is sexually assaulted while they're in college. And most often it happens in the victim's freshman or sophomore year. If anyone's interested in copies of any of the studies that we cite, you'll have the citations to these articles when you receive the materials. And if you'd like to have the actual articles, the journal articles, just send us an email after this webinar, and we'd be happy to forward them to you in PDF format. In 75 to 80% of the cases, the victim knows the attacker. So what we're talking about in these cases are non-stranger sexual assault cases. I avoid using the phrase date rape because it sounds a little bit like a less serious form of rape, but sometimes it's a dating situation, sometimes it's a friend or a classmate. Frequently, it's two people who meet at a party or at a bar or at some campus social situation, and that's where the offender finds the victim and then isolates the victim and then commits the crime that they're going to commit. In many of these cases, the victims are either drugged, drunk, passed out, or somehow incapacitated and helpless, maybe unconscious or even unaware of what's happening to them. And the research also shows that there are lots of male victims. This one study found that 6.1% of college males were victims of either attempted or completed sexual assaults. It's always difficult to get accurate numbers excuse me, on the rate of victimization, sexual victimization of males because the reporting rates are so low for male victims, much lower than for female victims. But it's a significant number of cases, and it's important to just be aware that they're out there. But it's less likely that these cases will come into the criminal justice system just because reporting rates are so low. It's really important that anyone working on these cases think about the central role that victims play in the process of participating in a criminal justice investigation, a trial, a prosecution, or even a campus investigation or a civil case. Victims need information. They need to know what's going to happen. And we as responders, I'm a former prosecutor, and we train a lot of prosecutors, police, campus judicial officers. It's really important that we ascertain what the victim wants and also making sure that the victim is being properly supported, that they have access to services, to the treatment, to therapy, whether it's a medical exam or supportive counseling, court accompaniment, medical accompaniment. It's so important that the needs of the victim be addressed. And sometimes it's the prosecutors and police who are in the best position to make those types of referrals to victims to make sure that they are supported throughout the entire process. In addition to being victim-centered, understanding the central role that victims play in these cases, we also need to focus our investigations and prosecutions on the offender. We need to realize that offenders are not committing these crimes accidentally, and they're not crimes that just spring up because an opportunity arose, but these are purposeful, knowing, intentional offenders who are targeting victims, and they're selecting their victims because for some reason they believe that they can be successful in committing the assault. And they may also believe that the victim, because of the circumstances or some other factors, is less likely to report the crime. And sometimes they're picking victims who they think maybe are less likely to be believed if they do report. A good example of that is a victim who is intoxicated, or a victim who is maybe smoking pot or using some other drug, where in order to report the crime and tell the truth about what happened, they would also have to admit to committing a crime of controlled substance use. So they know that, and we can't be swayed from looking at these cases seriously because the victim engaged in some petty crime or did some other type of wrongdoing, because we have to realize that offenders are looking for victims in those situations. And if we're not bringing those cases into the system, we're sort of giving perpetrators a pass who intentionally select that group of victims. We really need to focus on the actions of the offenders, understand the characteristics of these sex offenders, and focus on their intent to commit a crime and how they carried out that crime. It's not just the rape itself. It's all of the facts and circumstances leading up to the rape. The victim selection, the use of intoxicants, the means that were used to gain the victim's trust and then violate the victim's trust, to be alone with the victim. All of those things are part and parcel of how sex offenders operate. But on campuses, on college campuses, there are some other issues that really play a role in the dynamics of these cases and in the response to these cases. As we all know, there's a lot of alcohol being consumed on college campuses, and frequently it's being consumed by people who are not old enough to drink alcohol. That really can complicate matters a lot when someone is afraid to report because they're afraid that they're going to get in trouble for drinking underage. That may be both a crime and also a violation of the university or the college's student code of conduct. So there are essentially two sets of laws that a victim on a college campus is subjected to, and there are also two sets of laws that a perpetrator on a college campus is subjected to if the perpetrator is a student. That's going to be important, as we'll discuss later, when we talk about the victims' decisions about how to proceed. Do they want the criminal justice system to be involved, or do they prefer to proceed through university disciplinary hearings and that entire process? But we'll talk about that a little bit more. There are an awful lot of drug-facilitated cases on campus, and sometimes you have students who are voluntarily using drugs for recreational reasons, and sometimes you have drugs that are being slipped in victims' drinks or administered to victims surreptitiously so they don't know what they're getting. Some of the privacy issues can be profound on a college campus. It doesn't matter whether it's a small campus or it's a large campus. Students really do have a reduced amount of privacy because of the closed living quarters, because everyone kind of knows each other's business. There are dining halls where everyone's meeting and talking about everything that happened the day before, the night before, the weekend before, people talking about hookups, who had hooked up with whom, and sometimes when there's a sexual assault, that also becomes fodder for all of those types of discussions. These days with social media, you've got everything from Facebook and Twitter to Snapchat, Instagram, all of these things. These are all ways that people are getting constant information, and they're also ways that rumors and also truths spread very quickly across college campuses. And so the fear of someone being known to be a sexual assault victim could really dissuade someone from going forward and reporting a crime if they think that that information is also going to be distributed widely across campus through social media. Greek life, fraternities and sororities are sometimes separate subcultures within campus communities. Sometimes there's a lot of drinking associated with Greek life, especially in fraternities. I'm really not trying to fraternity bash here, but I'm speaking from experience as a prosecutor and also from experience as a member of a college fraternity when I was in college. There's an awful lot of alcohol being consumed in fraternity houses. Frequently, there's also a lot of drugs in fraternity houses, and often there is a hookup culture, a hookup mentality. Hooking up is not the same as raping people, but a sex offender can use the hookup culture to get a victim alone, to get a victim isolated, to get the victim's trust, and then violate that trust to commit a crime. In dormitories, in the residential life, there are also issues. There's a lot less privacy. Some of the dormitories these days are much more like apartment buildings with private bathrooms and kitchens or kitchenettes, but some dormitories still have shared bathrooms, shared recreational areas where people they just know everything that's going on. They can see people coming and going, and that also has an impact on reducing privacy and reducing victims' privacy as well. College athletics, university athletics also are a subculture of a college campus. Some of the same issues that we see in Greek life, especially the strong camaraderie, the alcohol use is also prevalent on some of the athletic teams. I can also say that in my own experience, many of the cases that I saw where there are multiple offenders, gang rape situations, almost every one of those cases that I worked on the college campus involved either a college athletic team or members of a college fraternity. There's something about that friendship and camaraderie just goes terribly awry and can lead to multiple offenders in these sexual assault cases. Finally, the issues of diversity. Frequently, campuses, especially rural campuses, are much more diverse than the communities in which they're located. You may have people from different countries, people who speak different languages, who dress differently, have different religious beliefs, and that can sometimes cause some issues when a crime has to be reported and it's being reported to a local police department that is perceived as somehow less tolerant or less welcoming of people from different races, different nationalities, and different ethnic groups. So that can also sometimes create a barrier to reporting a sexual assault case. We had a question from one of the participants already that someone chatted to Charlie, and the question is, let's see, how does one distinguish between a hookup and sexual assault? The line seems like it could get blurry when there is excess drug and alcohol use involved. That's a really good question, and it's an issue that comes up in a lot of these cases where you interview a victim, you talk to a victim, you read the police reports, and it seems very clear that the victim was raped, yet the defense is saying this was not rape. This was a hookup, this was consensual sexual activity, and that the victim is not telling the truth about the fact that it was either forced or that it was consensual. We're going to talk about most of these issues in a lot more detail, but I have to say, it always starts with a good, thorough investigation. And I have to also say that frequently, just reading the police reports is not sufficient to give you a clear picture of what happened in these cases. And in many of the cases involving college students, involving a lot of alcohol consumption, I would go that extra step of having a pre-arrest interview with the victim to talk about what happened. What do they remember? Do they know what happened? What is their version of what happened? Was there a lack of consent? Was there force? Was the victim unconscious or unaware that the sexual act was occurring? Sometimes when the defense tries to blur the line between a hookup and rape, it's not really a blurry line at all. When someone says, I did not consent, I would not have consented, and I did not consent, and the offender held me down, strangled me, forced my clothes off, penetrated me while I was unconscious. These are the types of cases that we're talking about, where it's clear that there was a lack of consent, and it's clear that there was some measure of force as well. But we're going to come back to these issues in a little bit. There are also some special populations of students that sometimes require some additional care. For example, students who are living off campus may feel much less connected to the services and also the programming that's available on campus. They may not be receiving the same training about resources, about the campus women's center, or where to go for a medical examination, that sort of thing. With respect to lesbian, gay, bisexual, transgender, questioning students, frequently LGBT folks start to come to terms with their sexuality when they start college, when they're away from their parents. And this could be a time when they're experimenting but may not be fully out and open to their family or even their friends. Someone who is sexually assaulted under those circumstances may also have a huge barrier to reporting, largely related to fear of people finding out about their sexuality before they're ready to tell anyone. If a student is not a non-native speaker of English or has physical challenges or is sight or hearing impaired, these are all different ways that someone can be perceived as more vulnerable and also less likely to report. And they are all folks that sex offenders could be targeting to commit these crimes against. You know that reporting rates for sexual assault are low. And when a victim of a crime reports that they've been sexually assaulted, frequently we're asking them to talk to a number of different people, a local law enforcement officer, perhaps a prosecutor, a victim advocate. If they're having a sexual assault forensic exam, there may be a forensic examiner involved in the case as well. But a victim on a college campus may have even more people to talk to. You may have to add in another police department, a campus police department, and a campus administrator may also be involved in this case. Depending on how the victim is impacted, and what services the victim wants to seek. There could be lots of other people the victim may need to talk about this: an academic advisor, professors, the dean of their college, their resident assistant. All of these people may play a role in the university's response to what happened to this victim and helping the victim readjust and get back to their life after this happened, and hopefully go on to continue to have a successful academic career. So when you think about the fact that we ask sexual assault victims who report to talk about very private, personal things that happen to them, often very embarrassing things. In the case of a victim on a college campus, sometimes they're going to have to repeat that information to a lot of different people, and that can be extremely difficult for a lot of victims. We had another question about what if the investigation indicates that both parties were in an incapacitated state when alleged sexual assault occurs. How does that impact the issue of consent? We're going to talk about that in a little while when we're talking more specifically about alcohol-facilitated sexual assault. I should also mention that we do have an entire webinar just on the question of alcohol-facilitated sexual assault, and that has been recorded. I delivered that webinar, and it's available on our website. So some of those questions will be addressed in there, but we're going to touch on some of those issues, although this presentation is not specific to the issue of drug and alcohol-facilitated sexual assault. So we are going to address those issues, but if you want a much more detailed presentation on that, you may want to just check out that other webinar as well after this one. So since we're asking victims to talk to so many people, it's important that all the different people, all of the different responders, be working together in a collaborative way. When a victim is coming into a system where everyone knows each other, where everyone is working together, where there are regular meetings and there are open lines of communication, it really does encourage victims to access all the services and participate in the process more fully. The research has also shown that when folks are working together in a sexual assault response team or a multidisciplinary team, it not only increases offender accountability by encouraging victims to go forward with investigations and prosecutions, but it also does result in improving community and victim safety. It sends a pretty strong message that a campus or a community is not going to tolerate a sexual assault, and that everyone's on the same page in terms of getting these cases investigated and, when possible, getting them prosecuted as well. When we talk about a sexual assault response team, we're really talking about a coordinated response that includes a broad range of all the necessary information, care, and services. And so if we go back to that slide, a couple slides back, all the folks that a victim may need to talk to, these are sort of the core folks who should be at the table at your start. On a campus, you may want to have your campus police, some campus administrators there, and possibly even folks from the different academic positions, university deans, representation from residential life, to make sure everyone's on the same page and that all these folks are working together so that it feels like a victim is coming into just a really well-coordinated system where everyone knows each other and everyone's talking to each other and everyone's there to help the victim adapt and readjust after the crime of sexual violence happened to them. Victims on college campuses frequently have more options than victims who are not on college campuses when there is a crime such as sexual violence. The victim can pursue the criminal justice system. They can pursue campus judicial discipline if the perpetrator is a member of the campus community, either a student or a faculty or staff at the university. The victim can receive medical treatment, and the victim can also consider accessing the civil justice system, whether it's a civil lawsuit against the perpetrator or some other person that was responsible for the crime in some way. If the offender was a current or former intimate partner, they may be eligible for a protection from abuse order. And there are quite a few states now that also have civil protective orders for sexual assault victims, even if there was not a current or former intimate partner relationship. Many states are now passing these, so you have to check your jurisdiction and see what's available. Some victims want none of these things. Some may want some of them, and some may want all of these. I can think of one case in particular where the victim did not, that I worked on, where the victim did not want an arrest to be made. She wanted to access the campus judicial system, and when that yielded a really, a really bad result, we made an arrest, we got a conviction, and there was also a lawsuit filed against the university because the perpetrator was a faculty member when the university had been on notice about sexually assaultive and sexually inappropriate behavior by that faculty member. So there are issues, and the victim needs to be connected with someone who knows what the issues are and knows what the options are, so the victim can make an informed choice about how to proceed in a case like this. If the victim decides to proceed through the criminal justice system, it's important for the victim to know that they are not going to control this process. They can make their report and they can participate, but it's ultimately the police department's decision how to investigate and whether to investigate. It's ultimately the prosecutor's decision how to charge the case and whether to charge the case. And as we know, the criminal justice system is extremely adversarial. It can be difficult for victims. There's a high burden of proof. It's proof beyond a reasonable doubt. Frequently, a defense attorney will be in court attacking the victim's credibility, sometimes attacking the victim's character in an attempt to make them seem less credible. And it's something for a victim to consider whether they want to go through that. Also, criminal trials are public, and there may be press in the courtroom. You never know. Many of these cases receive no media coverage at all, but sometimes they do, and the possibility of media coverage of a trial is something that the victim many victims are concerned about. We all need to be concerned, and we all need to be guided by what the victim wants to do. We need to find out what the victim wants to do. We certainly shouldn't be making arrests if the victim says, I don't want to testify in court, or I can't go through with this. Frequently, victims do want to go forward, and prosecutors are looking at the case, figuring out if there's enough evidence to go forward. But we always want to know, what does the victim want? Do they want to participate in the prosecution? Do they want there to be a trial, or would they prefer that there be some attempt to work out a guilty plea negotiation? All of these things should be guided by the victim. We can't always do what the victim wants, but we always want to find out what the victim wants, and we need to find out what is the victim's idea of justice. What do they want in this case? In terms of the victim who decides they want to go through the campus disciplinary system, there are some pros to that. It's much less public, and there's much more confidential because those proceedings are not open to the public. They're also generally less adversarial and can be perceived as more victim-friendly because you're not going to have the type of blistering cross-examination of a victim in a public courtroom that you might have in a criminal trial. The burden of proof is lower. In some schools, it used to be clear and convincing evidence, but now most schools, because of the Dear Colleague letter that came out from the Department of Justice, Office of Civil Rights, they've lowered the burden of proof to preponderance of the evidence. So it may just be much easier to prove a violation of the student code of conduct, right? You don't have to prove a criminal offense. You only have to prove a violation of the student code of conduct, which is frequently much more general and much easier to prove than proving the elements of a crime. And, of course, the rules of evidence generally don't apply in campus disciplinary proceedings, and hearsay may be admissible and may be more helpful in proving a case like this. There are some downsides to campus discipline as well. Sometimes when victims pursue campus disciplinary proceedings, because the victim is giving statements and is testifying at a hearing, sometimes it can create so many statements that it makes it difficult to prosecute a criminal case after someone has been through that. Certainly the offender is not going to go to jail or get a criminal record, and if there is a subsequent criminal proceeding, the defense or the prosecution could subpoena the proceedings from the campus disciplinary hearing, and all of those statements could be considered prior statements that may be admissible either as substantive evidence or perhaps as impeachment evidence if there are any inconsistencies between those statements and what the victim says in court at trial in the criminal case. we have to talk about alcohol-facilitated sexual assault, and we did already. And I can tell from some of the questions we've already had that this is a pretty big factor in these cases. So when we talk about alcohol-facilitated sexual assault, this is actually a slide from our 90-minute webinar and our 90-minute presentation on alcohol-facilitated sexual assault. The subheading, the subname for this presentation is Who Needs Force When You Have Alcohol? And the reason we put that there and the reason we asked that question is alcohol is such a powerful weapon for sex offenders. And I'd really be interested if you would chat your private chat your answers to Charlie Whitman. Why do you think alcohol is such a powerful weapon for a sex offender? Based on the cases you've seen, based on the interactions you've had with victims, why do you think alcohol is such a powerful weapon for sex offenders? Because it is, and it plays a large role in a lot of the cases we see on campuses. But if you could just chat your thoughts to Charlie, we'll go back and we'll revisit these in a little bit. When we're looking at alcohol-facilitated sexual assault cases, we're generally looking at cases where the victim is just too drunk to consent, either because they were given something surreptitiously by the offender, or because of the mixing of prescription or over-the-counter drugs with alcohol or some recreational drug, and sometimes it's just plain old recreational alcohol use or some recreational drug use by the victim that renders them incapacitated. The synergistic effect of a drug and alcohol is what happens when you combine two types of drugs. Alcohol is a central nervous system depressant, and it affects the central nervous system in one way, but when it's combined with a central nervous system depressant such as a Valium or a Xanax or an Ambien or something even like Benadryl, which also depresses the central nervous system, the combination of those two things is very powerful. It's like when you look at a medicine bottle for a sleeping pill or an anti-anxiety pill and you see that it says on the side, do not combine with alcohol. The reason for that is that the combined effect of the alcohol and the drug is much more powerful than just adding the sedative effect of alcohol to the sedative effect of the drug. It's almost as if the two multiply each other, and the impact can often be hard to predict, and it also sneaks up on folks. And when you combine these types of drugs, it's a very, very powerful combination, and it's used by sex offenders. And it's, again, it's probably the most common weapon that we see in sexual assault cases is alcohol. We got some responses from folks about the question about why alcohol, in your experience, why alcohol is such a powerful weapon. One person said the accessibility, ease of use, acceptance of alcohol on campus, absolutely. It lowers inhibitions, lack of usual judgment. It is a depressant. It makes the victim unable to fight or resist. That's all true. These are not the answers that I'm looking for, though, yet. Alcohol does blur memory. One participant said it blurs memory, incapacitates victims. Victims can't remember details, where, when, how. That makes it much harder to report and then prosecute. That's also true. Young adults turn to alcohol to fit in, to feel adult. They're more willing to use it. That's true. There's less taboo around alcohol than there is for other drugs. That's also true. It's an easy excuse for perpetrators to use to avoid taking responsibility. That's also true. One person said it causes doubt in the victim about their role in what occurred, and that's also true. But the real reason, the answer I was looking for, and by the way, all of those things are true and they're all correct, but the real answer I was looking for is that alcohol affects the way we look at cases. There is a double standard about blame and fault for victims and perpetrators. And when victims consume alcohol, frequently they are judged harshly and they are held more liable for what happened to them. Yet for perpetrators who are using alcohol, there's often a tendency to hold perpetrators less liable for the things they do while they're under the influence of alcohol. The truth is that voluntary intoxication is not a defense to rape, but some of the societal attitudes, and sometimes there's some sexism involved in this. We look at women who use alcohol and women who use drunk differently than men who use drunk. This is true in society, it's true in our juries, and it's true with judges too. And it's an issue that comes up over and over again. It's just plain old-fashioned victim blaming, but it's victim blaming in a much different way because it's victim blaming and then it's offender sort of not blaming. And it really plays out in these cases. And in many of the cases I've tried, it's become a predominant theme of the defense arguments right from the beginning during opening statements. Let's see. Let's keep going. A little bit of the toxicology of alcohol. It really is a powerful weapon. This is a quote about alcohol. It says, if recreational drugs were tools, alcohol would be a sledgehammer because it affects so many aspects of the body. It's a central nervous depressant, but in increasingly high quantities, it affects our ability to be awake and alert. It affects your ability to talk, to walk, to fight, to even remember what happened. It affects judgment. It affects so many abilities to function that it really is one of the sledgehammers of drugs. And just another site here on the prevalence of alcohol-facilitated sexual assault. More than 97,000 students a year between the ages of 18 and 24 are victims of alcohol-related sexual assault, or what this study referred to as date rape. And we also know from the research that if the victim was drinking or under the use of some drug, they're also less likely to report than victims of forcible rape. They're less likely to report to authorities. There are hundreds of reasons for that, but some of the reasons may be the self-blame about alcohol and also the fact that alcohol use by many college students is considered illegal because they're underage and they're not legally allowed to drink. There's a question, can you address effective ways to combat victim blaming effect of alcohol? And I'm going to talk about that in a little bit. Another question is, let's see, is it the case that state requires application of state criminal law definitions to sexual assault in Title IX, requires schools to define offenses using civil rights offense definitions? Oh boy, there's a lot of questions here. And I'm not sure I'm going to be able to answer all of these questions in the webinar. I may have to follow up after this webinar. In general, campuses are free to have student codes of conduct that define sexual assault the way that they determine is appropriate. Although there are some guidelines from the Department of Education about the things that schools should not tolerate and should treat very seriously under Title IX. I'm focusing primarily on the investigation and prosecution of these cases. And, you know, in terms of the crimes codes are pretty clear. And, you know, sexual assault without consent, by force, by threat of force, or with someone who is unconscious or unaware it's occurring is a crime. In some jurisdictions, they also have provisions of the law that say it's a crime if the victim is too intoxicated to consent. So we really have to just look at the elements that are on file, whether it's the crimes code or the student code of conduct, and we have to see if what the victim is describing establishes a crime or a violation based on the way the code or the statute is written. But there are so many challenges out there, and many of these challenges are related to just the attitudes people have about drinking and about even about sexual assault. I have just a few slides here. If you just Google, you know, campus rape or rape of an intoxicated person, you're going to find articles and discussions and blogs that deal with these types of things. Right, here's a T-shirt you might even see on a college campus, making fun of that statement, no means no. If you read the fine print, it says, have another drink. Blackout, don't pass out. We're going to talk a little bit about the difference between a blackout and a pass out. But alcohol is everywhere in our country. This study from 2003 found that 82% of people 12 and older have used alcohol at least once in their lifetime, and nearly half of all Americans have used alcohol in the past month. So, and look, I'm not making a judgment about alcohol. I grew up in a family where there was wine on the table, where my father and grandfather taught me how to make their afternoon cocktails. And so, there's no judgment here. It's just the reality. When some of the folks talked about alcohol being everywhere and being accepted, it really is accepted in our country and in a lot of other countries. But for the sex offender, they're going to use that acceptance and that widespread use of alcohol to commit these types of crimes. There's a difference between rape and drunk sex. And sometimes folks think that the two are the same. It's really the job of the investigators and prosecutors to show the difference between rape and drunk sex and show that they're not the same. And one of the things that we recommend when looking at these cases is what we call a two-step charging process. And this will sort of go a little bit toward one of the questions of how do you distinguish between a drunken hookup and rape. The first step is assuming that the victim's version is 100% true. Do the allegations constitute rape? Do they constitute a crime in your jurisdiction? Or for the purpose of a campus administrative proceeding, do the allegations constitute a violation of the university code of conduct? If they do, then the investigation should go forward, and the next step is, can you prove the victim's allegations? And whether it's in court or in a campus judicial proceeding, there are going to be obstacles, but there are also going to be things there that you can do. It starts with an interview of the victim, but it doesn't necessarily end with an interview of the victim. And boy, is it common. And we get these calls all the time from jurisdictions all over the United States, frequently from victim advocates, who tell us they're in a jurisdiction. It's sort of a tough-on-crime jurisdiction where they're going after drug dealers and car thieves and robbers and murderers and burglars. But in these same jurisdictions, when the victim walks into a police station and reports that they were raped while they were drinking or while they were drunk, those same officers who are so aggressive in so many other cases are telling the victims, you were drinking, there's nothing we can do. It's just going to be your word against his. And frequently that reflects an attitude where they're skipping over the very first bullet point here and going right to the second bullet point and saying, we're not going to be able to prove this case in court, so we're not going to do an investigation or we're not going to take a report. And that's actually happening with a pretty high frequency. We're still getting these calls. And it really does create a dangerous situation for victims and kind of almost like impunity for offenders. As long as they just find their victim at a bar, at a fraternity party, in some campus social situation where there's alcohol, then they are less likely to be prosecuted because that's just how cases are being handled in that jurisdiction. And that really is a problem. That's really a problem in getting justice in these types of cases. So what do we do? I mean, how do we look forward in these cases? It's important to realize that a lot of times the victim doesn't necessarily realize that what happened to them is the crime of rape. This study from 2004 looked at college victimization, and they asked victims about different things that have happened to them in their sexual past, including sexual violence. But when they asked the question, have you ever been raped, what they found was that almost half the women who described being victims of a completed rape in their questionnaire, when they were asked the question, had they been raped, almost half of them said no. So even victims themselves sometimes have these ideas of what the crime of rape is. And sometimes it's a stranger in an alley with a knife or a gun. And they don't think of what their classmate or their date or their ex-boyfriend did to them as the crime of rape. But rape is sexual intercourse by force or threat of force or without consent, whatever it is. And so victims sometimes have the misconceptions too, and that can really get in the way of prompt reporting. Someone chatted a question to Charlie about a report of rape, and the question is, if there's a victim whose perpetrator violated her 6 years previous, but now she wants to come forward. What is the likelihood of justice being done? There are a couple of questions that need to be answered there. First is it still within the statute of limitations? And second is it a case that can still be investigated and can still be prosecuted? It depends on a lot of different factors, and it would be impossible to answer that question now, but I'd be happy to answer that in a private one-on-one, either in a telephone call or by email. So I would just encourage that person to follow up after this webinar is over. We talked before about offenders who are drinking alcohol. A lot of criminals drink alcohol. I mean, I've worked on cases, homicide cases, where the perpetrator was drinking. People who robbed the 7-Eleven are sometimes drinking or using drugs. But the research also shows that about 50% of all sexual assaults are committed by someone who's been drinking. And in college students who are perpetrators, 68% of the assaults involved alcohol consumption by the offender as well. So again, I mean, the fact that someone is consuming alcohol, it doesn't mean that they're not a sex offender, but that can sometimes play into the way that we look at these cases, and sometimes it's used to minimize the liability of the offenders for what they're doing. Think about target selection when you're looking at these cases. This slide is intended to show that the good target for the predator is the exact opposite of the good witness for the prosecution. Frequently, offenders will look for someone who is drinking, who is drunk, someone who they think is less likely to report, less likely to be believed, less likely to participate with an investigation or prosecution, and that's who they commit these crimes against. I sometimes talk to prosecutors about cases, and they're talking about what happened, and the phrase "a bad victim" comes up. You know, I've got a bad victim. It's going to be hard to prove this case because I have a bad victim. And the truth is there are no such thing as bad victims. There are victims that are carefully selected by sex offenders, who, by the way, tend to be serial offenders. And they get really good at committing these crimes, at getting away with these crimes, and victim selection is a big part of how they often get away with these crimes. In terms of the second step of what we were talking about, remember the first step is assuming what the victim said is 100% true. Is there a crime there? The second step is, can you prove the victim's allegations in court or in a student conduct hearing? The victim's credibility in these cases is going to be central. Because most of the victims and perpetrators know each other, the defense is going to be either that the sexual activity occurred and it was consensual, or that no sexual activity occurred at all. Now with the prevalence of DNA and the widespread awareness of DNA, defendants are less likely to claim that it didn't happen, and they're more likely to claim that the victim is just not telling the truth about the fact that it was forced or that it was without consent. There are a number of factors that bear on the victim's credibility. What were they able to perceive at the time of the incident? What was their memory of the incident afterwards? Is there corroboration for what the victim is saying? And this last bullet point, this idea of victim likability, sometimes that really plays a role in these cases when defense attorneys try and attack the victim's character so that they appear unlikable, because if someone is unlikable, then they're less likely to be believed. I believe that these are some of the reasons why defense attorneys will frequently try and get out evidence of the victim's sexual past, why they'll try and introduce evidence of mental health history or the use of antidepressants, anything that they can do to make it look like the victim is either a drunk or promiscuous or somehow mentally unstable for some reason. Even if it's very trumped up like that, will all play into the defense of the victim is just not credible. There's not much we can do about the victim's perception at the time of the incident or the memory of after the incident, but there's a lot we can do as investigators and prosecutors regarding the corroboration. It's going out and looking for it. It's talking to people. It's doing just a thorough investigation and treating these crimes like the serious crimes that they are, right? Is there any corroborating physical evidence or medical evidence? Did the victim have a sexual assault forensic exam? Are there surveillance tapes? A lot of college campuses have them now. videotapes, tape recordings, recordings of still photographs. Was the crime scene photographed? Were the victim's injuries photographed? Is there some evidence that the victim was present in the perpetrator's apartment or that the perpetrator was present in the victim's apartment? Blood, hair, urine, semen, vomit, clothing. Depending on the level of intoxication, you may have vomiting. You may have someone who's not able to control, not able to prevent themselves from urinating because they're drunk and passed out. All of these things can play a role. When you have that, when someone was so drunk they were vomiting, when they were so drunk that they urinated, that's really good, strong evidence that points more toward incapacitation and less toward consensual sex, which is often going to be the defense in these cases. There's another question. Are there simple actions that bartenders can do to monitor and intervene when suspected alcohol-assisted rape preparation is in progress? Boy, that's a really great question, and I sometimes talk a lot about my own past. I also happen to be a former bartender, and I can tell you that bartenders and other servers can play a role in preventing these types of crimes. When you see someone who needs help, who is too drunk, hopefully the bartender or server did not serve them enough alcohol to be that drunk, but because that could lead to some liability issues. But making sure that someone has a ride home or calling a friend or getting them home safely, trying to find someone who is going to look out for them, and being on the lookout for someone who appears to be a predator, a sex offender, someone who is trying to take advantage of the fact that someone is incapacitated or is too drunk. That really is part of the role of and part of the responsibility that goes along with serving alcohol, and just being on the lookout. And it's also important for investigators to think about talking to bartenders or servers, or in the case of a party, other people who were at a party or other people who were serving alcohol at the party. These are all potential witnesses in a case like that. And frequently, the videotapes we were talking about may exist in bars and restaurants. Those black glass globes frequently in the roof, in the ceiling of a bar or restaurant may capture some of the evidence that we need to show how incapacitated a victim was. It's also really important that the accused always be interviewed. Sometimes, again, when these reports come in, the victim is told there's nothing we can do and the case isn't investigated, not even talking to the accused about what happened. Did the accused know the victim was drunk? How much did she drink? Were there signs of intoxication? This last bullet point, why does the accused think the encounter was consensual if he does? That's really important because sometimes people think that having sex with someone or penetrating someone who's unconscious is normal, but it's not even a crime. And the truth is it's a crime in just about every jurisdiction. But if this is, this person's idea of sexual gratification, they may unknowingly give a statement in which they're admitting to a crime without even realizing it. So, even if they're not willing to talk about the actual sexual act, the sexual assault itself, all of the facts leading up to the rape and all the facts that occurred after the rape. Someone who was driven a substantial distance to the victim's apartment and then fled on foot after this allegedly consensual encounter, sometimes that can be evidence of consciousness and guilt. It can be an important factor in these cases. So these are just all things to think about in these cases. Sometimes we use pretext phone calls in which the victim calls the perpetrator after the assault and talks to them about what happened. Your ability to do this depends on the law of your jurisdiction, whether you're a one-party consent state or a two-party consent state. So check the law, see what the requirements are, and also make sure the victim is well supported. It can be extremely difficult for a victim. But if a victim isn't even sure what happened, isn't sure that there was penetration, to call up with some ruse and say, I think I have a sexually transmitted disease. I think I might be pregnant. That may be a way to get the offender talking about what happened and establish that element of penetration that's necessary to prove the case. So think about this. If anyone's considering doing this, we'd be happy to walk you through it and maybe connect you with some other prosecutors who have done this type of work before. The bottom line is that the credibility of the victim is completely intertwined with the provability of these cases. And we have to do whatever we can to support the credibility of the victim. Once you interview the victim, once you reach the conclusion that this is a crime, that there was a sexual assault, the question becomes, how do you prove that? And there are some tools that we have that we know about, right? We've all heard this before. It's a he said, she said, or just a he said, she said. And frequently, there's a lot more than just the victim's version of what happened. So we have to look for it. We have to find it. So what are we looking for here? Well, we talked about some of these things, right? Eye and ear witnesses. It's rare that you're going to have eyewitnesses to the actual rape, although sometimes it happens. But eye and ear witnesses to what happened before the rape and what happened after the rape. Who's the first person the victim told? What was the victim's demeanor when they told that? Get that person interviewed. Many of the rape cases that I tried when I was trying these cases, that would be the first witness I called to the stand, would be what we call in Pennsylvania the prompt complaint witness or the outcry witness. Establish the demeanor, establish the report, and frequently when that report is made to a friend, a sister, a roommate, a sorority sister, the victim doesn't even want to go to law enforcement and doesn't even want there to be a criminal prosecution or even investigation. They just want to talk to someone about a traumatic event that happened to them. And those reports are very powerful because when the defense attacks a victim's credibility and says she lied to the police, she lied at the preliminary hearing, she lied at the trial, and they attribute to the victim some reason to make up lies and reasons to involve the criminal justice system, what was the reason the victim had to lie when she told her friend the exact same version of what happened and didn't even want police involvement? So I always encourage folks to find out who is that first person the victim told and interview them. And even if it's more than one person, interview all those people. Maybe someone did hear something when the assault was happening, especially in sometimes college living environments where there's not a lot of privacy. You can hear things even through the walls and so forth. Is there medical evidence? Getting that victim to a sexual assault forensic exam center as soon as possible. We used to recommend sending victims for a sexual assault exam if they report within 3 days after the incident. But now what we're finding, and the research is noting, that they're finding sperm cells and they can get DNA profiles from them as many as 5 days after the sexual assault. They're obtaining swabs from the cervix that have sperm cells that can get the offender's DNA profile. So it's also a good idea to just make sure the victim does get medical treatment for disease prevention, for pregnancy prevention, and to make sure that any of the consequences of the rape, any of the medical consequences or psychological consequences are dealt with at the first earliest possible opportunity, just for the well-being of the victim. Is there physical evidence? Photographs of the crime scene, collecting bed sheets or hairs or looking for bodily fluids, a sketch of the crime scene, sheets, clothing, underwear, whatever it is, torn clothing, any signs of a struggle. We don't necessarily need a mobile crime detection unit to go out to the crime scene. Just an investigator with a digital camera and some evidence bags is more than we really need and can do a really good job to just make this real when we're trying these cases, to just paint a complete picture for the jury about what happened, about where it happened, about how it happened. And these photos and these diagrams can be really powerful in the stand when the victim is going back and telling what happened and also showing the jury where things happened and how they happened and using the type of exhibits that we need. Also, expert testimony can be really important in these cases, whether it's a medical expert to talk about injuries or the lack of injuries and how that can still be consistent with that history of sexual assault that the victim gave the medical clinician. Also, maybe a toxicologist to explain alcohol, its effects on the body, to explain any other drugs we use, explaining the synergistic effect of combining drugs and alcohol together. If you have a victim that reports to an emergency room while they're still under the influence of alcohol from the same drinking episode when they were sexually assaulted, then we can use a toxicologist to relate back what the victim's blood alcohol content was at the time. And sometimes if that BAC is so high, that can be really powerful evidence that the victim was incapacitated. When it comes to corroboration, we just need to corroborate everything we can because there's almost always something more. It's just so disheartening when we hear the victims are being told that, they give a statement and they're being told there's nothing that can be done because there's not enough evidence to even investigate. And it's just so inconsistent to even say that because there's always something out there. We had a question that the perpetrator has the specific types of victims they're looking for, i.e. drunk. Can that also be considered a hate crime? I'm not aware of any state statute that makes it a hate crime status as a person with a disability makes the crimes eligible for hate crime. But I like the way you're thinking. I just don't think that fits in with any of the statutes. But that was always a big part of the arguments that I would make. When I talked about the intoxication and the premeditation and planning, I would always talk about the fact that the offender looked for someone who was vulnerable. They looked for someone who was drunk, and then they committed that crime. They went out that night with the intention to commit a crime, and they found someone upon whom to commit the crime. Another question is, do you advise campus police to do the criminal investigation as well as the Title IX? If so, how does the state comply with discovery? Since our statute says pretty much if police have it, it must be turned over to the DA for discovery, which may violate federal law for campus police. Every campus has to work this out, and it has to be worked out, probably with your lawyers. I can tell you that in my experience, the campus investigations, if there was a law enforcement investigation, the campus Title IX investigation would usually get their information from either campus police or from municipal police. Whereas if there was no criminal investigation, then the Title IX investigation would be done by on-campus folks. But I have to tell you, there are pros and cons for each one of these things. One of the things that the questioner points out is the discovery rules, that if it's something that the police have, it's going to have to be turned over. That's absolutely true. And there may be things that come out in the Title IX investigation that might otherwise be irrelevant in the criminal case. But every jurisdiction has to work on this. I'd be happy to take this question one-on-one afterwards, and we could talk through some of the pros and cons at that time. Some of the myths that are out there we've already talked about. That rapists are strangers, that they have got knives, that they have guns, that they inflict serious bodily injury. And the truth is that most rapists are not strangers, and frequently there are minimal injuries other than the actual injury of the rape itself. So if the crime that's being presented, the crime that's proven in court, does not meet a juror's expectation or a judge's expectation or a student conduct officer's expectation about what these crimes are about, they may be less likely to convict or believe that the person is a sex offender. We see it all the time where prosecutors, they prove their case and the jury still comes back not guilty. We call this jury nullification, and that's when a jury applies some other legal standard besides just applying the facts and the law and the burden of proof beyond a reasonable doubt. It's, yeah, we think he did it, but we don't want to call him a rapist, or we don't believe that this person should be convicted of rape based on that victim who drank so much or we think was promiscuous or whatever it is. So I always encourage folks to overtry these cases, to put in as much evidence you have, and also look for those attitudes, that rape myth acceptance, and start breaking them down from the very beginning in jury selection. Talk about rape and non-stranger rape cases. Talk about the lack of injury not meaning that there's a lack of rape. Talking about the elements of the crimes and how the law protects everyone, including people who are drinking or using drugs, those types of things. Non-stranger rapists, generally are not using knives and guns. They're using premeditation, planning, victim selection, manipulation, and deceit. They earn the victim's trust, and then they violate that trust. And that's such a common theme in these cases. If you trust someone, then you will let them in your home. You will enter their home. You'll let them into your car. And so often, non-stranger rapists are using these tactics to commit their crimes. When I argue these cases in front of a jury, I talk about the fact that this is a crime of premeditation and planning. Talk about the defendant as a predator, as a manipulator, as a planner, as a strategist. All of these things are true in these cases, and it's just important that we talk about them in these terms. So if you try this case just in terms of what happened in that bedroom during that 5 or 10 minutes, it's going to be much more difficult to prove than if you start at the beginning of the night when the victim went out and the perpetrator went out, who they were with, what they were doing, how they met, and how the evening progressed to the fact that the victim trusted the offender enough to either go home with him or let him into her home. We see it again and again, and it's important when you're trying these cases to really paint a complete picture of the before, during, and after the crime. Some of the research of Dr. David Leasack at the University of Massachusetts in Boston is really eye-opening when it comes to looking at these cases. He did a study involving 1,882 men in Massachusetts, and they were all college students. And he essentially gave them questionnaires and a series of interviews about things that happened in their sexual past. And what he found was that 120 of the participants in the study self-reported that they had committed the crime of either rape or attempted rape, but none of them were ever reported to the police or to the criminal justice system. Of those 120 college students, 76 of them were recidivists, repeat offenders, who had committed other rapes, either against the same victim or multiple victims. The average was 5.8 rapes per person in his research. And 70 of them admitted to other acts of violence. 97 admitted to committing rapes against women who were intoxicated because of alcohol or drugs. And this last bullet point I just think is so chilling. Of those 1,882 men, the 120 who admitted to rape or attempted rape had committed 483 acts of rape or attempted rape, and not a single one of them has ever been reported to the police. So we know this, right? The truth about rape is that most of the offenders are not strangers, and they're not using deadly weapons and causing physical injury. Another truth about rape is something that's difficult for folks to understand, and that's that there's a broad range of victim behaviors after sexual trauma. Some victims report right away. Some victims never report. But most who do report talk to someone or delay and figure things out and sometimes muster the courage to make a report in these cases. So there's a lot of shame. There's a lot of self-blame in these cases. But so often what we see are that victim behaviors that are not understood are used to discredit victims. It's done by defense attorneys, and sometimes it's done by police officers and prosecutors. I recently talked to a police officer who said that the prosecutor declined to prosecute a case of a campus sexual assault because the victim had destroyed the evidence. And I said, what evidence was she talking about? And she said she took a shower after the rape, which is a very common response to a very common reaction for someone to want to feel clean after having something like done to her. And this prosecutor found that so compelling that the victim had intentionally destroyed evidence that she wasn't willing to prosecute the case. They went back and they were asking for that decision to be reconsidered, and that's still ongoing right now. But the truth is that false reports are a small minority of cases. Sometimes there's a belief. We actually had a police officer in Philadelphia back in the 1990s who thought that all of the victims who came before him were just lying. And, if you believe that rape is rare and it rarely occurs and you see a large number of reports, that's going to reinforce your belief that rape is rare and that all these victims are lying. Common sense would tell us that when large numbers of victims are reporting, there must be a lot of rape out there. But for someone who has these preconceived ideas and really accepts them and believes them, sometimes the exact opposite happens. This has actually been studied in research, and the real rate of false reports is about the same in rape cases as it is in robbery cases or other types of cases. It's somewhere between 2 and 8%, depending on what study you look at and what the methodologies are. So false reports really are a small minority of cases. That doesn't mean that all cases can be proven, but just because a case is difficult to prove does not mean that the victim is lying. So we really do need to try and understand these victim behaviors and move forward and investigate these cases. Rape is never the victim's fault, whether it's what the victim is wearing, whether what the victim has done in his or her sexual past, whether the victim was drinking or drunk. I frequently used to argue to juries, there are a lot of consequences to getting drunk. You may get a hangover. You may miss school the next day, or you may miss work the next day. But a consequence of getting drunk, but rape is not a consequence of getting drunk. Rape is a consequence of the fact that there was a rapist looking to take advantage of the fact that another person got drunk. They were looking to take advantage of the fact that a person was vulnerable and easy to victimize because of alcohol or intoxication. And when you put it in those terms, sometimes it really starts to make sense for jurors in a way that they just never had heard before, or perhaps had never thought of before. When we're looking at overcoming rape myths, we have to do it at trial in the very early stages, educating the jury, sometimes by asking people on the jury panel about the experiences of them and their family. You may have someone, and it would be unfair to ask someone to talk about their own victimization in jury selection in front of a large group of people. But when someone says they had a friend or close family member who was a victim of sexual violence, just asking some questions. Well, who was the perpetrator? Was it someone that they knew? Because usually it will be. Did they tell the police? Why did they pick you to confide in about this? And what you're doing by asking those questions in front of the other jurors is you're starting to educate them about the prevalence of sexual assault, about the range of victim behaviors, about how difficult it is to report. And it really has power and it has value. Talking about these victim behaviors in opening statement, telling the whole story again, not just about the rape itself, but all of the facts leading up to the rape and all of the things that happened after the rape occurred. We need our investigators to corroborate everything that's possible. If the victim talked to someone, then get that person interviewed. If the victim went somewhere, where did they go? Get a map, get a picture of that place the person went, pictures of the crime scene, sketches of the crime scene, the clothes, the police report, the medical records. All of these things are so important. You know, a lot of times the defense argues that the victim is lying in these cases. Even though the victim walked into a police station and said, I was drunk, I was high, I was intoxicated, and he did this to me. If someone's going to make up a lie, they're probably not going to load that lie up with so many facts it's going to make them seem less credible. But the truth is the truth. When someone walks into the police station and tells the truth and says, look, I did all these things that I now regret, but I was raped, that really has power. So arguing that and talking about that in a way that the juries understand can really have value in these cases. As a prosecutor, there are also some things we can do to protect our victims in court because, as I said, this is a very adversarial process. But maybe a rape shield motion to prevent the defense from introducing evidence of the victim's sexual past that's irrelevant. There are other motions we can file that keep out irrelevant evidence. Maybe the victims, if they're going to try and show that the victim is a habitual drinker or a habitual drunkard, is that relevant? I mean, is the defense going to try and argue that intoxication is somehow a defense? It's not a legal defense, and we should shut that down and make sure that the defense doesn't make illegal arguments. Any prior bad behavior or behavior that can be seen as bad by the jury that the defense is going to try and bring in to discredit them, we have to think about ways to keep that out. Although for some drugs, chronic use could lead to building up a tolerance, which may be admissible in some cases. But the bottom line is to be creative, to think about what the defense is going to do, and is it really relevant or not. Frequently there's information in the medical record that may be relevant for a medical examination, but completely irrelevant for a sexual assault trial. Evidence of the victim's mental health history, their GYN history, that may be relevant in the medical records, but it may be completely inadmissible at trial. So go through them line by line. Make sure you understand every word and every term in those medical records. If there's something in there that is private and personal, that has no bearing on what the offender did to the victim, that can be an appropriate motion to eliminate, to exclude it because it's irrelevant. Regarding medical records, the research shows that a minority of victims who were incapacitated when they were raped had genital injuries. It's more common for them to have non-genital injuries, but even then, it's still a minority of cases. It's important to know this because jurors sometimes think that no injury means no rape. And you may need to call a medical expert to talk about this. This is all very well documented in the medical literature. And any sexual assault nurse examiner who's been trained in the last 10 years or so should be very familiar with this. If they've trained long before that, you may want to find out if they're up on the research and if they can talk about that. You may want to call a sexual assault nurse examiner as an expert, even if there was no injury at all, just to explain the lack of injury. And you may want to do that in your case in chief. There's a question from a participant: what impact, if any, does the use of a condom by a perpetrator have on the credibility of sexual assault reports? That's a really good question, and I've seen that in a lot of the cases that I've tried where the perpetrator uses a victim, uses a condom when they're sexual assaulting the victim. And in my assessment of the case, it has no impact whatsoever. There are lots of reasons why sex offenders might use a condom. The old-fashioned reason is for pregnancy prevention and also for infection prevention, STD prevention. But another reason for a sex offender to use a condom is to avoid leaving DNA behind that could be later used to prove the sexual assault occurred. So I've argued that. In fact, I remember one of the first cases where I made that argument, the defense at trial was making a really big deal out of this. And he said, come on, we all know that a rapist would never use a condom. That doesn't make sense. That's indicative of consensual sex. And my response was, you know what, there was a time when people got a sexually transmitted disease and they went to the clinic and they got a shot of penicillin. But now we have viruses that can't be cured. And everyone knows that, including sex offenders. So they're going to commit the crimes that they're going to commit, but they're also going to try and protect themselves to commit additional crimes or to stop leaving or to avoid leaving evidence behind. So in my assessment of a case, that never weighed against the victim's credibility. But in sometimes a jury's assessment, it's something that needs to be explained and it needs to be talked about. I've had cases where victims were fighting back and saying, please don't do that. And then finally, when they realized they couldn't fight back anymore, the victim said, please use a condom. And sometimes the offender did do that. That does not mean that it was consensual. Someone who's begging for their life to avoid getting what could be a terminal illness does not mean that the whole case was, the whole incident was consensual. So again, it really involves talking to the victim, finding out exactly what happened, what the victim said, what the victim did, and what the perpetrator said and what the perpetrator did. In terms of trying these cases, there are kernels of truth that come out in these cases that will sometimes win the day. And we need to create the reality of these crimes for the jury and get out as many relevant details as we can. I talked about before this idea of offender-focused prosecution. The defense will frequently try and keep the focus of a criminal trial on the victim, how much the victim had to drink, what choices the victim made, how the victim trusted the offender and allowed the victim to be alone and vulnerable with the offender. But this case is not about a trial of the victim. All of these cases are about a trial of the offender. The jury instructions that the judge gives the jury at the end are going to be all about the offender's conduct, not the victim's conduct. So it's important that we keep the focus on the offender and that we have themes where we focus from the very beginning, from the opening statement, all about the keeping the focus on the offender. A theme like who needs force when you have alcohol, or a predator picking his prey, a man with a plan, the perfect friend. He earned her trust, and then he violated that trust. And then just going back to that theme throughout the trial. We need to make sure that our victims are prepared for these trials. They're going to be cross-examined about their alcohol use, about their drug use. It's important that they tell the truth. If the victim reported underage drinking and got a free pass in disciplinary proceedings because of that, they may make a big deal out of that and say that she fabricated the rape so she wouldn't get in trouble because of the underage drinking. The truth is that usually the consequences of a citation for underage drinking are very minor, not worth making up a lie that would potentially ruin another person's life. But they're going to try and grasp at something to put some ill will or ill motives on the victim. If there's memory loss, if there's a delay in reporting, and this last bullet point that they frequently try and portray the victim as a promiscuous party girl, that's a big part of these cases. You just see it over and over again. But the bottom line is the victim just has to be honest. They just need to tell the truth. If someone's going to be convicted of rape, they should be convicted based on the truth. Whether it's alcohol use, whether it's drug use, whether it's prior consensual activity with the offender, or either on the night of the incident or before, that may be admissible under the rape shield law, and you just have to deal with that. And again, the victim should not try and shade the evidence to somehow help the prosecutor's case. The truth is the truth. And if there's something that the victim doesn't remember because of alcohol or because of the neurobiology of trauma, then that's okay. It's okay to say, I don't know or I don't remember. There's no reason someone should have to feel like they should fill those gaps by making something up that's going to try and help the case, because it's just improper and it just shouldn't be done. I talked about this a little bit already, but the use of a medical expert to explain the lack of the injuries. Again, this is important because the jurors sometimes think that a lack of injuries means a lack of rape, and it's just not true. We know that unconscious victims can't resist, and so a lot of times if the victim was unconscious, there will be no defensive injuries. There will be no torn injuries, maybe no torn clothing, You may have injuries such as like bruising on the thighs, that type of thing, or injuries to the outer parts of the body just from being intoxicated and being moved or carried or dragged somewhere when the victim was intoxicated. So all of this can be important. It can also help corroborate the victim. If you have someone who was too drunk to consent, and that's a way that these can be proven in your jurisdiction, then that may be something that you may need to call an expert for. Maybe a sexual assault nurse examiner, for a pharmacologist, a toxicologist. Think expansively about experts. Anyone who can help with these types of cases may really help the jury just understand some areas of the facts of these cases that they otherwise may not know. We have another question that came in. Let me pull that back up. What use do prosecutors typically make of investigators' notes or reports created by the university in adjudicating cases internally? Are such records frequently game changers in the criminal proceedings? You know, it really does depend. Investigating sexual assault cases is a little bit of a specialty among law enforcement. And the good investigators who do a lot of this get really good at what questions to ask and what questions not to ask. Sometimes I see questions that were asked in the internal investigation, and I just kind of scratch my head and think, ooh, I really wish you hadn't asked that question. That's really going to open the door to something that I'm going to need to keep out of this case. So the bottom line is, though, the university investigation, the Title IX investigation, it has to go on. And the criminal case, most likely, if the prosecutor thinks there's probable cause, is going to go forward too. So sometimes we just have to reconcile the fact that there have been two separate investigations, and we're going to have to try and get justice for the victim and for the offender, even though there may be some obstacles. The biggest obstacle in that a student investigation, a campus investigation creates in the criminal case is the existence of prior statements. Because victims, when they talk about the same incident over and over again, there are always going to be minor differences. There are going to be things that defense will construe to be inconsistencies. And it's those inconsistencies that can be really blown out of proportion at trial to make it look like the victim is lying. When in fact, it's typically normal. It's perfectly normal for a victim to just tell something slightly different. They're not reading a script. They're reliving a traumatic event that happened to them, and they're trying to answer questions about it as best they can. So that frequently is the downside, is the fact that multiple statements can lead to sometimes perceived inconsistencies in these cases. That's not a reason not to go forward, but it is a reason that a jury may have trouble with the case. Frequently, the defense will be subpoenaing the campus disciplinary records. Consequently, the prosecutor will also subpoena them because the prosecutor wants to know whatever the defense has in their file. So these are just some of the ways that these things play out where, repeated statements by witnesses can lead to inconsistencies. There's another comment. I think we're coming up on time, though, so I'm going to have to take that one after. I'd be happy to respond to the victim in an email. So, going forward, what do we do with these cases? What have we learned here? Well, what we know from the research is that a coordinated community response on campus and also in the jurisdiction is helpful. It's helpful for victims, and it's helpful for information sharing. The fact that these different investigations are all going on at the same time is important, and everyone who's working on these cases needs to know and needs to be trained together. Multidisciplinary trainings on campus with all members of the team are amazing. Letting the police know what the campus is doing, letting the campus know what the police are doing, letting the prosecutors know, the victim advocates, whether they're campus-based or community-based, making sure that everyone's on the same page, everyone knows where to go for a sexual assault forensic exam, what that exam consists of. These are all really important things. We need to make sure that our victims know all of the options that they have. Campus discipline, criminal justice, medical, civil legal proceedings, all of these are part of the mix. And after someone has been a victim of sexual violence, they've had some control over what happened to them taken away from them, and to give them some control back by telling them what their options are and letting them decide what to do can be part of helping them readapt after the trauma of sexual violence. And then finally, just keeping the focus of these cases on the offender. Understanding that the victim's choices are going to become an issue, and they're going to be made an issue by the defense, but we shouldn't make that an issue. Almost all of these cases involve a victim who trusted someone who later betrayed them and turned out to be a sex offender. And just talking about these cases in those terms and understanding them in those terms and explaining them to our judges and juries in those terms will go a long way to getting some justice for victims and some accountability for offenders. This is my contact information. I'm going to hand it back over to Charlie to conclude the webinar.
Thank you all so much for your participation and your questions today. I also want to thank Chris for all of the great information you provided, and thank you all in attendance for your dedication to increasing victim safety and offender accountability in your communities and across the country. When you exit iLink, we just recommend that you visit our website at equitasresource.org, where you can register for future webinars and training events and review additional information about Equitas, including archived webinars, like the one Chris was talking about on alcohol-facilitated sexual assault. You'll also be receiving a link to a SurveyMonkey evaluation for today's presentation, along with the PowerPoint presentation, PDF of today's PowerPoint, and Chris's full biography. Please respond to the follow-up email if you're interested in information regarding CLE credits. And please do remember that AEquitas is a 24/7 technical assistance provider and is available to respond to questions, concerns, and training needs as they relate to prosecution of violence against women. On behalf of AEquitas, thank you all so much for participating in today's webinar. Have a great day.